line with the SRC Constitution, and therefore the seventh schedule adopted contradicts Chapter 6, Article 38 of the UHAS SRC Constitution. The Electoral Commission, after disqualifying Mr. Vakwa Bright, called for a clandestine meeting on September 6, 2022 with Mr. Vakwa Bright and tried to coax him into accepting his disqualification. This action undermines the entire vetting and electoral process. This action by the EC raises great concerns of the unjust dealings in the entire vetting process. If truly the Electoral Commission had legitimately done its job by the Constitution, why then would the EC chair call for a meeting to coax Mr. Vakwa Bright into accepting his disqualification? Balance of convenience. The petitioner shall be made to suffer irreversible harm if a temporal injunction is not immediately laid on the electioneering process, as the petitioner will be disqualified unconditionally and will be unconstitutionally denied the right to be voted for. The Electoral Commission will, however, suffer negligible harm if the injunction is not granted. Priors. Grant a temporal injunction on the ongoing electoral process until the matter brought before the court is fully determined. Reverse the unconstitutional decision of the Electoral Commission to disqualify Mr. Vakwa Bright based on the 80% pass mark. Order the Electoral Commission to reinstate Mr. Vakwa Bright as a legitimate federal candidate. Order the Electoral Commission to allow Mr. Vakwa Bright to participate in the SRC election. Reverse the decision of the Electoral Commission to remove my client, Mr. Vakwa Bright, from the presidential race, since the constitutional instrument does not clearly state that disqualified aspirants shall not be denied the right to be voted for. The marks awarded for some criteria are unsatisfactory, and therefore the Honorable Court of Justice should investigate the scores. Parties directly affected by injunction, UHAS SRC Electoral Commission. Conclusion. It is therefore respectfully submitted that if this application is allowed, the injunction sought on the electoral process be granted, the disqualification of Vakwa Bright be reversed, and Vakwa Bright be allowed to contest in the SRC election. Document to bank on for this application. Vetting results indicating that Mr. Vakwa Bright has been disqualified. Letter addressed the EC requesting for basis of disqualification. Letter from the EC informing Mr. Vakwa Bright on grounds of disqualification. The constitutional instrument, the SRC Constitution. This and any other documents the court may subpoena for its processes. I am of high hope that the court is administering fairness and equal justice. And equal justice will heed to my prayers. Submitted to the Superior Court of the Judicature of the SRC Court of Justice. Submitted by Mr. Obin Gideon, Lead Legal Counsel for Petitioner, and Mr. Fosu Gregory, Lead Counsel for Petitioner. Petitioner, Mr. Vakwa Bright. Then
after a thorough read of the petition, we shall inquire if both parties are present. So we start with the plaintiff, Mr. Vakwa Bright. Good. So the plaintiff is present. The defendant, the Electoral Commission of this SRC. All right. Since both parties are present, we shall proceed to ask them if they represent themselves or they have a legal counsel to represent them. So we start with the plaintiff. Mr. Vakobright, do you please have a legal counsel? All right, good. The Electoral Commission, are we having a legal counsel? Are you having a legal counsel? Good. So may you please approach the bench with details of your legal counsel. Approach the bench. We mean come to us. All right. So the legal counsel for the plaintiff, that's Mr. Vapor Bright, is Gideon Obey, Mr. Gideon Obey, and you may sit on my left. Plaintiff, so legal counsel and the petitioner sit on my left. The legal counsel for the Electoral Commission, Eugene Teria, together with the Electoral Commission representatives, sit on my right. All right, so the court shall proceed. A little bit of what went on before right now. So we had a pre-trial conference where both parties presented exhibits that are going to be used in court, as well as ask themselves some salient questions to ensure that both parties are on the right path or on the same path, and also the justices are kept abreast with whatever is going to be happening here. So we are going to skip the part where exhibits are going to be presented to the court. So we've already seen those exhibits, and the ones that they are going to use, you are also going to see them. So good. If everything is set, then we'll proceed to have the opening statements from the plaintiff. You have 15 minutes max. Before you start, so with the opening statement, you don't give us the details of whatever you are coming to argue. I hope we are okay. We'll get to that side. When you get to the cross-examination, you can do everything. So just give us why you've convened the court here and whether we should proceed to hear you or not.
Good morning, my lord. On the 1st of September 2022, the Electoral Commission circulated a letter with reference UHAS SRC EC 000, which consists of the vetting results for this year SRC aspirants. In this letter, the name of my client, Mr. Vapor Bright, was tagged in quotes disqualified. With respect to the aspects of the SRC Electoral Commission's CI, which states that aspirants demands to know the basis of their disqualification or qualification will be duly informed after the formal request has been issued to the commission to that effect. My client wrote a letter dated 2nd September 2022 with reference EC/VR01 to the Electoral Commission requesting for the basis of his disqualification, in quotes. The Electoral Commission's basis for, in quotes, disqualifying my client, Mr. Vapor Bright, according to the letter reference UHAS /EC 0 shows only one score sheet of an overall score 8.2255, which is very questionable and unsatisfactory, and I will prove to this fact. On September 8th, my client was removed from the UHAS SRC aspirants page. After the Electoral Commissioner, in quotes, disqualifying my client, he called for a clandestine meeting to jostle and cajole him in accepting his disqualification. EC question. My client, Mr. Vapor Bright, has been a very excellent student leader in all reputs and served under various capacities in this university and has groomed himself to be the UHAS, to be an SRC president. At this juncture, I would like to make a few clarifications. 1. We are not against the application of the CI in the conduct of the ECs, in the conduct of the election as stated in Article 6, as stated in Chapter 6, Article 44 of the UHAS SRC Constitution. 2. We are not against the Electoral Commissions as a person, but the conduct of his office. 3. We are not against the members of the vetting panel, but against the conduct of which their work was carried out. 4. The EC has no legal right to take my client out of the election race. And these and several others I would prove to this court. I rest my case.
Thank you for the opening statement of the plaintiff. The defendant, shall we have your opening statement? Legal counsel for defendant. Your opening statement.
Good evening. Sorry. Good morning, my lord. I'm in the person of Eugene Rekuteya, the legal counsel for the defendant. To begin, I would like to make certain clarifications concerning the petition at hand. First of all, I would like to make clear the fact that the constitutional instrument which comprises the rules and regulations of the EC, of which the EC uses in regulating the electioneering process after it has been submitted to Parliament and has been approved by Parliament, becomes the Schedule 7 and is annexed to the Constitution, which makes the CI binding and then exercisable in accordance with the Chapter 4, Article 11, Subclause B and C of the 1992 Constitution of Ghana, and then Chapter 6, Article 44 of the UHAS SRC Constitution. Secondly, no part of the Constitution states that the EC cannot hold a meeting with disqualified aspirants of the election, of any election, sorry. I therefore plead with my lord to ask the petitioner to retract his statements as such. I would also like to cancel out certain statements in the petition I believe to be factually incorrect and hence should not be there. First of all, the petitioner states in his first argument that the electoral commissioners basis for disqualifying Mr. Vapobright, that's the petitioner, as in the EC's letter for explaining basis of disqualification with reference UHAS SRC EC 22007, shows only one score sheet should be crossed out, since the response actually stated that the score sheet presented was an average and total collated score of all 8 score sheets presented by the vetting committee, and not just one score sheet as stated by the petitioner in his petition. 2. The petitioner in his third argument states that the 80% ground for disqualification is not in line with the SRC's constitution, and therefore the 7th schedule adopted contradicts Chapter 6, Article 38 of the UHAS SRC constitution. This statement is factually incorrect and hence should also be crossed out, since the grounds for disqualifying candidates from running in an election actually covers the whole of Chapter 6 of the UHAS SRC constitution, not just the Article 38 of the Chapter 6 of the UHAS SRC constitution. And the 80% pass mark is a part of the CEI, which becomes the Schedule 7, which is annexed to the law and hence exercisable with reference to the Article 46 of Clause C of the UHAS SRC constitution. So I'm here today to prove to the court that the petitioner's issues stated in his petition are invalid and therefore should not be paid attention to. Thank you.
Thank you very much for the opening statement of the defendant. We now move to cross-examinations. So, for the cross-examinations, we'll start with the plaintiff. So the plaintiff will first call the one you are representing, that is the petitioner or your client, to the box, which is the seat there, and you cross-examine him. After that, the defendant will have a chance to also cross-examine Mr. Vapobright. Then the same thing will be done for the Electoral Commission. So the legal counsel for the defendant will cross-examine the Electoral Commissioner, and after that, the legal counsel for the plaintiff will also have a chance to cross-examine the defendant. So we start with the plaintiff, Mr. Vapobright. You kindly take it.
What religion can you swear by? Please repeat after me. I solemnly swear I solemnly swear that anything I say in this court will be the truth. So help me God. May sit down.
Robinson. So, Mr. Bright, between the hours of 2 to 3 p.m. on the 7th September 2022, where were you?
I was at the hospital.
You were at the hospital. Okay. So, between that time frame, you didn't go anywhere again. You were only at the hospital.
Yes, please.
Okay. Did you have any meeting with the EC?
Yes, please.
Who called for that meeting?
The EC.
The EC called for that meeting.
Yes, please.
Can you tell before this honorable court that the reason why the EC called for the meeting?
No, please. He just sent a WhatsApp message that he would like to meet me.
So can you tell us what
Yeah.
actually went on at the meeting?
All right. So at the meeting, he asked me. He asked me how far with, or how am I taking the disqualification so far, and I told him that he called for the meeting and I'm only here to listen to him. So he continued by saying that disqualifications do happen, and also he doesn't want any issue. So why won't you just let this issue go? And I said okay. So I've heard him.
Okay. So this is actually a message from the EC requesting to see my client, Mr. Vapo Bright, after the release of the results, to cajole him into accepting his results. But the question is that if the verdict of the EC is too clear enough and is too fair enough, then why then should you have to meet my client without the knowledge of the student populace? Why do you have to meet my client to cajole him and then to convince him to accept the disqualification that you have given to him, even if your verdict is too clear enough? So this is a very huge question that puts a credibility on the work of the EC. Because if my work is too fair enough, there is no need for me to explain myself to Mr. Vapo Bright. Okay, Mr. Vapo. So how did you feel when you saw the vetting results?
Well, I was so devastated because I wasn't expecting it.
Good. So when you take a very good look at the footage, you can see that there was not even a single question that my client wasn't able to answer. So with this expectation that my client had within him, when he saw the results, he was really down, And then the problem of this whole thing is that this results was also published on media houses, on other websites, and even on our UHAS-based TV, our YouTube channel as well, which has put in an emotional stress and physical stress on my client upon all his good work, all his preparation that he has been preparing towards this vetting, just to come out that he is being, in quotes, disqualified without any ground basis of that. So, my lord, the basis at which they disqualified my client is questionable. And two, if the verdict of the EC is too clear, the question is, why then should you have a meeting with my client without the knowledge of anyone? And I might also believe that it's not only my client, but maybe other aspirants who were disqualified might also be involved in this situation. And you had a meeting with my client without the knowledge of anyone, without the knowledge of the student populace, just to cajole him that he should accept the vetting results. And then the underlying word is that he said he doesn't want any problem. So the question is, what have you caused that you think will bring a problem? Thank you very much. I rest my case.
So, shall we have the counsel for the defendant cross-examine the plaintiff?
Okay. Good morning, Mr. Brightsburg.
Yeah, good morning.
To start with, I would like to ask you. After you were disqualified, was there any communication, any form of communication between you and then the EC?
Yes, there were several communications.
Several communications.
Yes, please.
Just answer me with yes or no. Was there
Yes.
Any? Yes, there was a communication.
Yes, please.
Who contacted the initial communication?
So initially, I sent a letter asking for the basis for my disqualification.
And so you are saying your first communication was through a letter?
Yes, please.
All right. And then the reason for sending the letter was to
Request for the basis for which I've been disqualified.
So are you saying you never made a phone call to ask for a refund from the EC?
I was requesting if it could be possible, because it wasn't stated in the CI that the money couldn't be refunded or anything. So I was just trying to seek clarification on that.
Seek clarification?
Yes, please.
And so you didn't ask for a refund? Yes or no?
I seeked clarification whether it is possible.
Did you ask for a refund? Yes or no?
No, please.
You didn't ask for a refund?
I was seeking clarification.
All right. On which day was the meeting held? 7th of September. All right. Thank you. My next question is, you were the NAMSA president, which gave you the legal right to be a member of parliament, as at the time the CI was being presented to parliament, right? You were a member of parliament. Right? And were you concerned about the 80% pass mark as it being inhumane, as at that time you were a member of parliament? Yes or no? No. You weren't concerned?
I didn't raise any issue.
You weren't concerned, yes or no?
I didn't raise any issue on it.
My question is, you weren't concerned, yes or no? And so why didn't you raise an issue? If you say you were concerned, why didn't you raise an issue?
Because the CI didn't explain the basis on which the 80% will be scored. So I can't raise any issue against it.
You are saying the CI didn't state the basis for which
the 80% will be scored. So I can't raise any issue against it because I don't have any basis.
you don't have any basis.
Basis on which the 80% will be scored.
All right. So why then now that you are raising the concern about the 80% pass mark?
Because now I was told by the EC, I've gotten a response from the EC on the basis.
On the basis?
On which the 80% will be scored.
Okay. I rest my case.
After the cross-examination of the plaintiff by the defendant's counsel, shall we ask the plaintiff to excuse us to his seat? Justices, do you have any question? Okay, then please remain in your seats. Yeah, do you have any questions? Okay.
So you agreed that you made inquiries concerning whether your money can be refunded to you back, right?
Yes, please.
So is it that if the money can be refunded to you, you drop the case and take your money and walk away?
That wasn't specified. I was just inquiring whether it is possible.
Is that what you meant? I want to be very possible. What?
I was just asking,
That's
could it be possible
that your money will be
that
refunded.
the money will be refunded?
If yes, what's next?
I didn't say it.
We didn't say it. Okay.
So you started by showing it, right? And the first time of a message is 7:23 a.m. From that, I see another message coming in 9:52 p.m. Between 7:23 a.m. and 9:52 p.m.
So can I please have a look at the exhibit? All right, so this would be September 6. Yeah, because September 7 is at the bottom.
At the bottom.
Yes, please.
Okay. So, just a quick clarification on that one. So, supposedly what you've given is true. I want to ask, on the basis of clarity, who started the initial conversation between you and the EC?
As I said earlier, after my disqualification, I sent a letter to the EC. That was the first communication.
So the first communication was started by you?
Yes, please. Okay. But with respect to this meeting, the EC called for it. Can you meet me at 10 a.m.
No,
tomorrow?
I just want to know who started the first conversation. So you started the first conversation?
Yes, please.
All right.
And I've been engaging him.
And you did the call for the refund, right?
I was inquiring.
You, okay, but
an inquiry. Yes, please.
Okay. When was that call done?
I can't remember.
Why can't you
But it
remember?
was after the disqualification.
So can it be a day or two after?
I can't actually remember.
From the time of the first initial letter you wrote to the EC concerning the disqualification to the time of the meeting, what is the last period?
I would say few days, but I can't.
Can you quantify?
No, please.
Fact here.
No, please.
You can't quantify.
But I can say it's within few days. Let me say a day, 2 or 3. Yes, please.
Okay. And also, I think there was an issue raised on the issue of the CI, right? And its constituents, the constituents of the 80% mark, right?
Yes, please.
Can you tell us the problem you have with the 80% mark?
All right. So, as clearly stated by my counsel, we are not against the CI being enforced as law.
Okay.
Yes. So we were having problem with the 80% because.
So you had a problem with the 80%.
Yes, I had a problem with it.
So I want to just tell us what problem do you have with the 80%? Is it the individual component that sums up to the 80%?
Yes, please.
So that's what you have a problem with.
Yes.
Did you read the CI?
Yes, please.
So have you read a vetting of aspirant section C?
I've gone through the CI.
So do you know what is in vetting of aspirant section?
No, I can't from my mind right now.
So should I read to you?
Yes, please.
So vetting of aspirant section C. The criteria for the vetting shall be determined by the vetting committee. Were you aware of that?
Yes.
How do you understand this statement?
It means that the criteria for the vetting will be determined by the. Come again. Can you take it again?
The criteria for the vetting shall be determined by the vetting committee.
Yes, so it's self-explanatory. That's what it means, and that's how I understand it.
So that criteria embodies constituent.
Please, I don't understand. I don't get that question.
We are saying that the criteria for the vetting shall be determined by the vetting committee.
Yes, please.
Right?
Yeah.
And within that criteria, we have a mark, something 80%, right? Do you understand that then?
Yes, please.
And so since the criteria is determined by the vetting committee, the criteria will have components. Yes or no?
Yes.
Do you understand that then?
Yes, please.
So it means that they will determine the individual components that
will
of sum up to the 80%.
Exactly.
You
yes,
understand?
Please.
You understand it? Okay. So do you accept that the criteria will be will be set by the vetting committee?
Yes, we understand that fact. The CI actually gives that authority that the vetting panel will determine the criteria that will be used to vet the aspirants.
Okay.
So as we stated earlier, we are not against the CI. Okay, we are not against the CI. What we are trying to say about that is that the marks awarded.
I am saying that the marks that is being awarded is coming from a criteria.
Exactly.
Okay. So the marks is coming from a criteria which has individual components within it, right?
Yes.
Which is going to be determined by the committee.
Yes, and I don't have problem with that.
No. I just want you to understand it.
I understand it.
So it means that it has individual components which, when it sums up, it will determine someone have more than 80% or less than 80%. Or
yes, please.
Okay. So I seem not to maybe understand you. So do you have a problem with the individual components which is going to be determined by the committee?
We don't have problem with the components. Our problem is how we were scored.
So your problem, so now what you are trying to emphasize is how the scoring was done.
Yes, please.
So your problem is how the scoring was done.
Yes, please.
But not the individual components.
No.
I hope that is clear.
Yes.
So your problem is the scores.
Yes, please.
For each of the components.
Yes, please.
Okay, thank you.
Mr. Bryce Vapo, you classified a meeting as being clandestine, yet still you attended this meeting. You would think there was something to do with the meeting that was a bit dicey. What did you do? You should have taken some measures if you knew that maybe that meeting was illegal or was going to not profit anything good, or it's bad. You shouldn't have attended the meeting, but you went. You didn't report to anybody that, oh, the EC wants to have a meeting with him, is it right or something? But you still went to the meeting.
All right. So I know the EC, and I also know him, even before he became the EC. Okay. So he called, kindly meet me at 10 a.m. I don't know whether it's about my disqualification or it's about our personal relationship. So I can't just decline the meeting. I have to go and understand what the meeting is all about.
So, but why are you now complaining of this 80%, the scoring or whatever? Whether it's debatable, whether it's with the manner of scoring, the criteria for scoring, because we don't. Why are you now complaining about it? You're a parliamentarian. You were present for the Zoom meeting. I'm aware. You were there. You didn't raise any concern about it.
So I believe the council asked the same question, and I explained that the CI states that they will determine the criteria for vetting. They didn't specify the criteria, and also they said the 80% is pass mark. It could be that when you are academically qualified, you have passed the 80%. It could be. So I can't raise any issue at that time because I don't know what it entails. But right now, the issue is about how we were scored, not about the 80%. We are not seeking that it's the 80% should be reduced or anything. But I can also make reference.
But you're scoring. But
yes,
you're scoring. Okay.
Yes.
So now that it has gone
and please, so
you,
just a minute. You asked a question concerning why didn't I raise any issue about it. Yes, and I explained to that effect. And also, I want to tell the court that there was a resolution during 2019-2020 academic year by the SRC that the basis for the baseline for passing vetting is the academic qualification, which is a CGPA of 3.0. Okay, so I have no evidence here, but
then if you do not have any evidence, then it's inadmissible.
No,
now.
But this is the school, so it can be cross-checked whether I'm lying or not. It can be cross-checked.
Please, we gave you a time during the pre-trial to give us exhibits you are going to use during the hearing. It means you don't put an extra burden on the bench to go and do your work for you. And so that evidence you are pointing to is inadmissible in this sitting. We'll move on if you have anything else to add to that, but that resolution is inadmissible in this sitting. And a quick word to all the counsels and the defendants and the plaintiff. If you come here with any evidence which falls within the scope of the exhibits you presented to us during the pre-trial, it's inadmissible for this sitting, as we clearly stated to you within the pre-trial. So, well, I think I have a question. So, with the exhibit here, right, there was a discussion at around 7:23, and you typed, Mr. Vakobright, you typed that this basis is clearly against the Constitution, okay? Which means that there was a prior discussion about whether it is constitutional or not. And at 9:52 p.m. on that same day, the electoral commissioner texted you, "Hello, kindly meet me at 10 a.m. tomorrow." It means that there is a logical coherence that the meeting can be pinpointed to the fact that you are going to meet them to discuss something about the election. So you have to prove to the bench how it is not linked, as in how you thought the the meeting was so out of the world and it's not something that is linked to it, because that was a prior discussion to he meeting or he calling for the meeting. So I think you have to throw more light on that.
All right, so my lord, I attended the meeting because the previous communication was about it being constitutional or unconstitutional. So that the meeting would be about this. Extra clarification.
But please, I will not cut you short. You just told the court that you had no idea about what the meeting was going to be about. So you were thinking
so this
it's
is
going
an
to be about
assumption.
Yes, so an assumption is an idea. But you told us you had no idea about what is going to happen. So can we get clarity there? It's very important.
All right, I said I had no idea because someone called for a meeting. Anything. This is the assumption. I can't say that it's because of this. Please, I believe you are understanding. All right.
My last question. If okay, this extrapolation. So can we also, since you are telling us that the EC called you to a clandestine meeting to cajole you, right, to accept the election or the vetting results, okay, can we also extrapolate that every clandestine meeting that went on was for one party to coerce one another? That is to say that your call that you placed to the EC was also an attempt to coerce the EC. Can we draw that logical gap on the bench?
No, please. As
Okay.
I stated,
So how is yours peculiar to, like, how does your clandestine meeting prove a coercion?
because of the content of the discussion. I called initially to ask for clarification. I contacted the EC to submit a letter requesting for the basis. That doesn't make it clandestine. Yes, but what makes this peculiar one clandestine is the fact that he tried to tell me that disqualifications happens. So to avoid any issue, why can't you just let it go? All right, so whilst going to meet him, I met one other aspirant who was also disqualified, who is in the person of Emmanuel Apalu. So we actually met in front of the administration and we worked together in front of F2. So upon reaching there, we met him in front of F2 ward and he said he wants to meet us separately. So he met Mr. Emmanuel Apalu.
But there's no actual evidence, or you don't have any actual evidence on the meeting that, on the conversation you had with the EC chair. You don't have any, apart from having a witness who also had a different conversation, which we are not privy to. But to yours, you don't have any evidence.
It was just the two of us in the meeting.
So how am I supposed to take your word against this? That's the problem.
So this is the only evidence I have that the meeting was called.
All right, so this will be left to the discretion of the bench. And we take you take your last question. I can see you're already tired, so you take your seat.
Oh, so can I answer one after the other? All right. So I requested for the basis of my disqualification. So I just want to know the reason why I have been disqualified, because when the issue came out, a lot of rumors were all over the place. Or he academically he didn't qualify. Why did he even bother form in the first place? There were a lot of issues on grounds. So I just want to know the basis on which I was disqualified. You get it? So that was the response I had from the EC. So I wasn't satisfied with it. That is why I went on to petition the court. Yes, please. So as I already explained, the basis for scoring of basis will be vetted stated in the CI. So I can't question it. Please, do you understand? It was just stated in the CI that the pass mark shall be 80%. I just made a clarification that there was once a resolution. There was once a resolution that the academic qualification shall be the baseline for passing vetting. So it could be by. So I have a question.
Please, Madam Clerk, please can you turn in the exhibit of the Electoral Commission, the exhibit 1 of the Electoral Commission, the one that bears the theme of Team Bright. I want to have that exhibit, and then, sorry, or the EC, please can you give us the exhibit again? Mr. Bright, you have a team Bright, right? You have a page like that.
Yes, please.
And then I believed your number is 054 101 2074.
Yes, please.
That's your number.
Yes, please.
Okay, so if we call, we can get you now.
Yes, please.
Okay. Sunday, September 4th, you sent a message to your followers on your page. I read, "Good evening, Team Bright. I sincerely apologize for the late update. The issue of my disqualification is now at the office of the Dean of Student Affairs. She affirms that the election process shall not proceed. The election process shall not proceed unless the issue is resolved. I encourage you to keep hope alive whilst what we work on. She works on the issue for us. She works on our case for us. Sorry, my temper is getting high. Thank you very much. Progress for UHAS." That's the message you've sent on that platform. I believe you sent that message.
Yes, please.
Thank you so much for admitting that. So my question is, since the Dean has given you a very good assurance, so what do you want the court to do for you today?
The Dean did not give only me assurance. She met the Electoral Commissioner and myself.
Yeah.
And she has assured or affirmed the two of us.
Mhm.
I don't know if he can attest to this fact, but we met him. The two teams met the Dean of Student Affairs.
Two teams.
And she has affirmed that whatever be the case, it shall be resolved.
Okay, let me proceed again. You have been a student leader, a president, of course, I believe so. Yes or no?
Come again.
You have been a course rep before. From course rep, you moved to a student leader, a president for the nursing. Sorry if I get the association.
Yes, please.
And then you moved to be a member of parliament. So I believe you know the various channel of communications, right?
Yes, please.
The SRC court was there before you proceed to go to the dean. Am I right?
I wouldn't say I proceeded to the dean. What brought the dean into the picture is the request that I wrote. Request for basis of disqualification. And
Have
I
you copied the dean
of student affairs.
Uh-huh.
And I also copied the entire student populace.
Okay.
So when she saw the letter, that was when she came into the picture. Yes. And I also copied her because she is the dean of student affairs. So she should, or she is concerned with everything that happens with students. So I deemed it necessary to just copy her. So that was what brought it. That was what brought Dean to the picture. I didn't say Dean should come and do anything, because you made a statement that the SRC court was there. I know the hierarchy of communication. Why do I bypass the SRC court and go to Dean? I just copied her.
Okay.
Yes, please.
Thank you so much for your clarification.
Just some few clarifications, then we are done. Okay. Chapter 6 of the UHAS Constitution, Article 47, talks about the composition of the vetting committee.
Yes, please.
The 46, the same chapter, 46, the vetting committee shall have the power to disqualify any candidate for any election under this constitution on grounds stated only in the constitution under Chapter 6 or the 7th schedule. Are you aware of that provision?
Yes, please. So,
having the back, the CI, also Chapter 6, 8, gives the electing committee the mandate and the power to be able to disqualify an aspirant.
that is true.
So why then are you fighting?
All right. So as I stated, or as my counsel stated, we are not against the CI.
I'm not saying
neither
the CI. No,
are we against the vetting panel.
No, listen to me. The vetting committee was composed from 47 of Chapter 6 of the UHAS SRC Constitution. And they were taken through vetting process as stated in 47. Do you know of that?
Please, I don't get you.
When you read 47 of Chapter 6 of the UHAS SRC Constitution,
can I have a copy of the Constitution, please?
You can give it to him. Sorry. So it talks about
the composition of the vetting committee. Okay.
And when you read the last, I don't know whether you see or something, it's saying that they go through a vetting process.
Okay.
So before they become members of the vetting committee, it's not based on any merit, but they are actually vigorously vetted and chosen.
My lord, I even have question an issue with that aspect.
You didn't raise it in your prayer, so we are not there. It is not part of your prayer.
But you are trying to question me with respect to that.
No, what I want to just create your indulgence. I'm just creating your indulgence that the vetting committee provision was made in 47. So the vetting committee was not based on any merit. One. Do you agree or not, or you don't agree?
Was based on
any merit, as in people chose their friends or something. Do you agree or you don't agree?
Please, I don't get the whole thing. I don't really get the whole thing.
47C talks about the 47.
All right. Thank you very much, Mr. Vakpo Bright. You may now take your seat. Would invite the legal counsel for the Electoral Commission together with the Electoral Commissioner. So the Electoral Commissioner should take the box. Take the stand. Yes. Cross-examinations first.
I solemnly swear that anything I say in